This Honorable Court of Appeals of Tennessee is in session. Please be seated.
Good morning and welcome to the Court of Appeals. Come on, step on up. Let's see. Before we get started, we've got the TV people in the back, camera crew. Thrilled to have you. Just try to be as unobtrusive as possible, if you would, please, because we don't want to interfere with any of the arguments. Thank you. Miss Angie, anything we need to take up before we call the next case?
No, Your Honor.
All right, you may call the case, please.
Janet Doe versus City of Memphis, Tennessee.
I will note for the record that we have two cases that are related, and we will hear the arguments back to back. They are separate arguments. There are separate case numbers. They have not been consolidated for any purposes other than that. You may proceed.
Good morning, Your Honor.
Good morning.
John Lakey of the Shelby County Bar and the law firm of Birch, Porter & Johnson for the City of Memphis. I would reserve 4 minutes for rebuttal, Your Honor.
4 minutes. All right, sir.
The city has presented, we're really starting with the Rule 3 brief, the Rule 3 appeal, which is the issue of class certification that was granted by the trial court. The city's presented the court with extensive briefs on this issue, and we certainly rely on those this morning. Today, I intend to address any questions, of course, the court has, but in addition, 4 reasons why this court should reverse the trial court. And the foundation of our argument throughout that will be that the trial court failed to engage in the rigorous analysis that it's required to undertake before certifying a class. And that's pretty clear in Tennessee law that has to be done. The 4 arguments. First, the plaintiff really failed to propose an appropriately specific definition for their class and that it was seeking to certify, and thus the trial court failed to define a class whose bounds are precisely drawn as is required under Tennessee law, and we're going to start with that one. Second, we contend that under Rule 2301-2, the plaintiff cannot satisfy commonality as required under the Tennessee Rules of Civil Procedure, and likewise under 2301 they cannot satisfy typicality and adequacy. And then, as the court knows, if you satisfy 2301, you move to 2302 under the Tennessee's Rules of Civil Procedure, and we do not believe they can fulfill those requirements. Obviously, the standard of review when reviewing a trial court's grant or denial of class certification is abuse of discretion. Although there's a bit of a mix because the court does look at whether the court has applied the right factors. Among other things, the trial court abuses its discretion if it applies an incorrect legal standard or strays beyond those legal standards. And where legal conclusions are involved and whether the trial court used a correct legal standard in making a certification, that decision is a question of law. These are complicated cases. There's a lot of facts, and I do think it is incumbent upon me to give the court some background before I dive into my analysis. The case arises from the announcement by the City of Memphis in the summer of 2013 that there was an inventory of sexual assault kits of approximately 12,000 that had been collected from victims of sexual assaults from 1985 forward, and that it was in possession of those and was going to conduct a full and complete audit to determine the status of testing. There was a statement at that point that 12,000 SAKs had not been tested. That was a statement in the summer of 2013. That inventory went back to SAKs that dated back to 1985, which was many years before DNA evidence was routinely used by law enforcement for any purpose, and 17 years before the combined DNA index system, that's CODIS, became available to Tennessee law enforcement. And CODIS is a database that's maintained by the federal government that allows law enforcement that have been certified to use it to be able to take a DNA sample and compare it to the DNA that's in the database. Without having access to CODIS, Your Honors, the only thing law enforcement can do with DNA is compare it to a known suspect. And that will become important when we're talking about this class. When the inventory was completed in 2014, MPD announced and reported to the Tennessee Bureau of Investigation that there were 11,864 SAKs in inventory. 3,670 of those had been fully tested, 1,552 had been tested for serology, and that of the 6,642 that had not been tested, 5,683 of those were from 1985 through 2002, before Tennessee law enforcement, any Tennessee law enforcement, had access to CODIS. Now, the sole remaining plaintiff in this case is Janet Doe, who was sexually assaulted on June 11, 1997, and who submitted to a forensic examination during which biological and trace evidence was collected, which, among other things, might identify a perpetrator. It's 1997, and at that point, the only way to use that DNA evidence as a law enforcement officer in Tennessee is to have a known suspect's DNA to compare it against. That did not happen. There was never a known suspect identified, and there was no ability to access CODIS until 2002. So I'm going to move through this really quickly if I don't dive into the analysis. Yes, Your Honor.
There are many reasons besides negligence or recklessness that one would not submit pre-CODIS kits for analysis and entry into CODIS, aren't there?
So pre-CODIS, you couldn't even submit. But yes, Your Honor, even after CODIS was available, there were legitimate investigatory reasons why one might not have submitted an SAK for a DNA test.
Like the person's already arrested, or you have lots of evidence identifying them other ways.
Or even that the suspect doesn't debate that he had sex with the victim, but says it's an issue of consent. Yes, Your Honor, those are all reasons. And so what we have here, and one of the biggest problems in this case, is you had 3 initial plaintiffs who filed the lawsuit, all of whom it turned out their cases were dismissed on summary judgment, summary judgments were pending, and they withdrew their cases because their SAKs had been tested timely. And then the initial plaintiff, Megan Ebos, her claim was dismissed on statute of limitations on grounds. Here, the trial court initially erred by not defining a class, and even if the court had commonality, which we say it didn't, the court never entered a class definition. And I think the easiest thing to do is to take you to the court's ruling, and the court's ruling with regard to the class. It's on page 5 of that order, and that is at record 22 at 3088, I believe, Your Honor. Therefore, this court finds that on the issue of class certification, based upon Tennessee Rule of Civil Procedure 23 and the submission and arguments of counsel, plaintiff has sufficiently satisfied Rule 23 such that the court should certify the class. Additionally, the court finds that while plaintiff has to find the class it wants certified, the class is broad and would require the court to entertain arguments regarding subclasses and further modifications to the class. So, Your Honor, one thing the court has to do if it's going to certify a class is define the class. Here, the trial court was not aided by the plaintiff, because the plaintiff proposed an extremely broad class. And in their reply brief, or their response brief to our appellate argument, one of the things that the plaintiffs have argued is, well, the trial court really was adopting our class definition by reference. And that's the only language in the order which I read to you, where the court discusses the granting of the class and anything that can be related to a class definition. But with regard to the plaintiff's motion, Your Honor, what the plaintiff's motion sought was, and that's at paragraph 1 of their motion for class cert, it's cited in the papers, the named class representatives and similar situated claimants are all individuals who submitted to the dramatically invasive process of providing the city of Memphis with sexual assault kits concerning the charges of rape. So it's everyone who's ever submitted a SAK to the city of Memphis related to a sexual assault. And that's where we get into the issue and a problem with commonality. To satisfy commonality requirements under 23012, of course, it's not enough to simply say you're raising common questions, even common questions in droves. You must show that class-wide proceedings are capable of generating common answers that are apt to drive the resolution of the litigation. A common contention of such a nature that's capable of class-wide resolution. Here, individualized questions dominate. There are a host of reasons, as we've described in our papers, for why a sexual assault kit may have been tested or not tested in a given situation, especially, Your Honors, when you're looking pre-CODIS, pre-2003. What the record is clear that, and even Mr. Waller, who is the plaintiff's proposed expert, says that before 2003, the city of Memphis didn't have access to CODIS. So the only investigatory reason then to have DNA tested pre-2003 is if you have a known suspect. There is no dispute. There was not a known suspect in this case.
Why will subclasses not take care of that problem?
Well, Your Honor, they have not even asked for subclasses. There has not been any discussion of subclasses. And we have to deal with the class that's been certified. Right now, the class that's been certified, I read to you what the court said. It's not clear at all. But what plaintiff says is, what she was doing, what the court was doing, was adopting our request in our motion to certify. That motion to certify says it's everyone who submitted an SAK. And during this period, that's going to be around 12,000 class members, including, Your Honors, I would point out, the 3 initial plaintiffs, all of whose cases have been dismissed, either by the court because of a statute of limitations or by themselves after being faced with summary judgment motions that showed that their SAKs had been tested timely.
I'm sorry, but may I ask one more
Certainly,
question?
go right ahead.
There are also 2 other aspects I'd like you to comment on, and I apologize for taking extra time. The timeliness of the request aspect. This request occurred 4 years after the filing of the lawsuit, and the rule says do it as soon as practicable.
Right.
The other question I have regards, this is a case that seeks a lot of damages, and is that appropriate under our rules?
Well, Your Honor, 2 questions that I think are important, and they're going to be important also for our next particular appeal that we'll be discussing, which is the motion for summary judgment based on the statute of limitations, Your Honor. But yes, we as we briefed in our papers, Your Honor, the delay of over 4 years. We see the case was initially filed by the initial plaintiffs on August 15, 2014, and it was almost 4 years later that the motion for class cert was filed. And that was after the plaintiffs, the initial plaintiffs, one had been dismissed and a new plaintiff had been amended in. So we do believe delay is an issue, and we've addressed that in our filings. And then with regard to the second question, Your Honor, which was, I'm sorry, will you take
It was
me down
about
again?
damages.
Yeah, the damages. And so that changes the entire case. When you look at the first amended complaint, or first complaint that was filed, the initial complaint, which was amended within about a month later, so we refer to both of those as the initial complaint filed by the 3 initial plaintiffs, what was sought was $1.5 million in total, with $750,000 being sought from both of the governmental entities. At that point, Shelby County was also a defendant in the case, Your Honor. And when Miss Doe is amended in, that claim goes to $10 million. And we do believe that's an issue. We have motions that are pending in front of the trial court, and of course we have a stay in that case, and so we have motions to address that in front of the trial court. So those aren't in front of this court for decision today, but we do believe that's an issue, and one in which Should the court not grant our second motion, which is the motion to, in essence, the motion to overrule the court's decision not granting our summary judgment motion on the statute of limitations, and that's something will have to be addressed.
The stay, was it a stay that we issued, or is it
No,
a
it's
stay?
under Rule 3, with regard to class decisions, it's a rule that it's an automatic stay.
I assumed it was a global stay. so-
It is. It's a stay in all discovery in that case.
Okay, all right, thank you.
Thank you, Your Honor.
You still have your rebuttal time.
Right, thank you.
Gary Smith of the Memphis and Shelby County Bar for the plaintiffs. I want to begin by addressing a couple of the questions that have been posed. to
Mr.
Ms.
Smith, are you making the entire argument?
I am.
Or do you have co-counsel?
I shall.
Go ahead.
A couple of the questions that were asked of Mr. Lakey, and then some of his opening comments. And I want to start with this. The very first thing he told you was that this issue was revealed back in 2013 by the city's announcement of 12,000 rape kits plus that had not been tested. The city did not make such an announcement until after this scandal had been exposed by investigation by the media. And when it was exposed, they didn't admit to 12,000. It was many multiples less than that until further investigation showed that the scandal was much longer. Second thing he said was that many of these are pre-CODIS and that the city nor any other law enforcement agency had access to CODIS before 2002, and therefore no suspect cases were not permitted to be submitted. There are two things horrendously wrong with that statement. Number one, it ignores that the retired agent of the TBI from that testing unit has given an affidavit in this case that said pre-CODIS non-suspect cases could be submitted to the TBI for testing. Number two thing that's wrong with that is that even if they were right, which they're not, that they could not submit no suspect cases before 2002, it does not explain why, once they could submit no suspect cases after 2002, they did not. They allowed this backlog to continue to build up. In the case of Ms. Doe, who was raped in 1997, it results that her kit was not submitted for testing for 18 years, not until 2015, after this scandal had already been exposed and after the statute of limitations had run on her perpetrator. And so now let's address the issues under Rule 23. By the way, and Mr. Lakey said the biggest problem in this case relates to the three original plaintiffs. The three original plaintiffs are not in the case anymore. We're talking about Ms. Doe, and that's where the focus has to be. He also addressed Your Honor's question, Judge Stafford, about subclasses, saying we have not asked for subclasses. It is not time to do that yet. Judge Bennett asked about the timing issue, and he said that's, quote, a problem. I don't know what that means, but I do know why it was not asked for sooner, because the city moved that discovery not be allowed on the class, and we did not get relief from that order until this motion that was granted certifying the class in 2023. The reason why there was a delay, and there is no required time parameter for filing for class certification other than as soon as practicable, and practicable was interfered with by the city insisting that there be no class discovery. It is a little bit difficult to move for class certification when you have not been allowed class discovery, but we did get some discovery under that limitation that afforded us the opportunity to have sufficient information. It came by the hardest, but we got it. So
So there was no class discovery until you moved to certify a class, and then there was some discovery?
There has been no class
Been
discovery to this
okay.
day.
Okay.
Now, in fairness, we did get some information in the meantime, but the order prohibiting class discovery was still in effect up to the time that the judge entered the order certifying the class and saying that it had been an impediment to us in developing all of the information, but we did get enough. Now it is time for class discovery so that some of these issues can be addressed, such as, should there be a subclass? In the end, this is not complicated. There are 4 elements to Rule 23. Mr. Lakey complains on behalf of the city that the judge failed to define a class. We know what the class is. It is the rape victims who, at the city's request, submitted to this invasive, painful, degrading procedure of a rape kit, and they were not utilized.
Does that go, how far back does that go?
It goes back into the 80s. It does go back into the 80s, but it continued up until the time that this scandal was uncovered, which was within a year of the time that this lawsuit was initiated.
So you know on the back end, you're going into the 80s, and I assume it's an open-ended class on the front end. Would that be right?
Well, if I understand what you're saying, at this point, everyone whose kits are not tested that are going to be identified once we finally get the identification of all these victims from the city are potential class members. But we do not have...
Going forward in the future, I'm assuming. Or I don't know what the status is now as far as rape kits.
What we understand the status to be, but yet we have not been able to verify, is that they have changed their policy and that they are timely testing now. But for right now, we are concentrating on what happened up through these 12,400 plus, not to mention the several thousand that were thrown away into the city dump without being tested. We have proof from within that department. I'm sorry.
What about, you say you have the class defined, but what about the judge's quote that the plaintiff has to find the class it wants certified? What does that mean if that doesn't mean you don't really have the class defined yet?
I think we do have the class defined.
And what did she mean?
I'm not sure what that sentence taken in that context means, but I think everybody, including the court, understood. We are talking about rape victims who submitted to tests whose kits were not tested. Now, we can get into, in our second argument, some details with respect to why that testing is important and why these victims relied on it. But we know that the class is the rape victims who submitted to the test at the city's request/insistence, and then they did not utilize it. And there is proof from within that department, from a man, a lieutenant who twice worked in that department, who saw this problem, who protested this problem and was told by the city to shut up, who said that he saw, not even looking at all 12,000 of them, but he saw examples in the hundreds, if not thousands, of these cases that we're talking about, where once the kit was secured, instead of doing an investigation and submitting the kit for testing, they were simply closed in violation of the rules without supervisory authority into cyberspace, and those kits were put into a warehouse where they were not even inventoried to know where they were. Clearly a violation of appropriate police standards. There are 4 elements that have to be met. Numerosity, the city doesn't even contest that one, but as Mr. Lakey indicated, they contest commonality. Commonality only requires that there be commonality of law or fact common to the class, but importantly, the most important feature in commonality is that there is commonality of a wrongful course of conduct, which clearly there is here. The city will never be able to excuse this backlog. And under Rule 23, under commonality, the questions common to the class simply have to predominate over questions that are peculiar to individuals. They don't always have to be precisely the same. It's just that the questions common to the class, in this case, failure to test and delay in testing, is clearly common to the class, and commonality is satisfied. And the third element, claims of the representative plaintiff, are typical of the class. We know what it is here. Failure to test for 18 years. And they can protest it being pro-cordis, pre-codis, as they have indicated they do. I've already addressed, they could have done it pre-codis, according to the TBI agent. But even post-codis, they waited 16 more years to test her kit. The issue is not testing and delay, and Ms. Doe's claim is typical of that, of the other claim members. And under typicality, under the Freeman case, the Supreme Court has said claims don't have to always, or the Court of Appeals has said, claims don't have to always involve the exact same facts or law, provided there is a common element of fact or law, and that clearly does exist here. And the fourth element I don't think they contest is that Ms. Doe will fairly and adequately protect the class. It's really interesting that the city argues here, we say incorrectly, that we do not meet the test under Rule 23 for commonality and typicality, when they are the very ones that argued for and obtained an order to prevent class discovery, which would be revealing on commonality and typicality. Again, on the passage of time, Judge Bennett, there is no rule on absolute time. We know that the Supreme Court of Tennessee has addressed that one time on a Rule 23, but it was because of Davidson County's locality rule, a 30-day rule. That's the Tig versus Pirelli tire case. But there is no rule other than as soon as practicable, and as soon as practicable was influenced, as I said in this case, by the city seeking the prevention of class discovery. In effect, what the city argues here under some metaphorical, theoretical pretense is that they cannot be held accountable for a scandal of epic proportions that they created. And they contend that that's true because where we have traveled on Rule 23 is inapplicable. So let's pull back the curtain on that and see what it reveals. Are they really saying that there should be 12,400 individual cases filed and that that would be the appropriate path? That is exactly, precisely what Rule 23 is designed to avoid when there are numerosity matters such as this. In the thousands, Rule 23 is specifically designed to do that. We respectfully ask that the court, in giving deference to and under the abuse of discretion standard, honor the ruling that the trial judge has made, certifying this as a class and allowing us to move forward. Thank you.
Thank you. I believe you have 4 minutes, Mr. Lakey.
Thank you, Your Honor. Just to address a few of the points Mr. Smith has raised. First, with regard to the affidavit that he refers to. I did not stand here and tell you that you cannot, that there was no ability to submit a DNA sample to TBI prior to 2002. What I said to you was that there was no way to use that without a suspect to which to compare it. Did TBI apparently accept some no suspect DNA evidence before 2002? Yes, perhaps it says it did, so I take it at its word, especially with where we are in this case. But what he did not say was that there was any investigatory purpose.
tell me how this works. If you submitted a test to the TBI, who pays for that? Does that come out of the TBI's budget?
I think it does, Your Honor, and it has
Okay.
changed over time as well. And so I don't want to guess at what it was like in 1997.
I thought
and-
there was some suggestion about resources influencing and some attempts to raise money.
Well, there is a discussion of that, Your Honor, and that's with regard to actually conducting an inventory of the SAKs.
Okay.
And putting man-hours into coming up with a list of all of the SAKs. Remember, the way SAKs were stored until this issue of CODIS arose was by investigation. And so if there was a suspect, if a suspect had been identified in Ms. Doe's case at some point, that suspect would have been identified. They'd have gone back, seen that an SAK was attached to her investigation, and they would have been able to submit both. So I wanted to address that affidavit. This issue of discovery. Let's talk about it in the context of what happened in this case. The initial plaintiffs came forward, 3 initial plaintiffs. The city moved to limit discovery to those plaintiffs and not have class-wide discovery. And in fact, that was a decision that by the court that the court made. The court ordered it. The city didn't get to decide not to participate in discovery. We moved the court, and in fact, those 3 initial plaintiffs were all dismissed from this case. When you read their brief, the only thing they really complained about is they couldn't find out numbers and identity and things of that nature. Well, the number wasn't in dispute. They've cited the number over and over. What they really wanted was to be able to identify potential additional plaintiffs to add. And it is not unusual for a court pre-class certification not to provide that information to plaintiffs. And they took it.
Sort of the chicken and the egg argument, isn't it?
I don't think so, Your Honor. I think that what they have to do is look at the plaintiffs that have come forward to them. There's also been a massive amount of press.
They had plaintiffs who came forward.
They did, and they did come.
And they fell by the wayside, as it turned out.
Well, right, and they have 1 left. And to suggest that she has commonality, that her claims are common, with 12,000 SAKs that were collected from 1985 through 2012, I think is belied by the proof that's in the record. And I would also note this, Your Honor, that this suggestion they couldn't verify the policies that the city of Memphis put in place relative to their SAKs is not supported by the record. The deposition of Deputy Chief Crow is in the record. They took 2 depositions of Mr. Crow, or Chief Crow. First one was with regard to Ms. Doe in particular, and the second one was with regard to his affidavit, which dealt with all of these issues. I see I'm out of time.
Thank you.
Thank you.
Gentlemen, we will take this matter under advisement. We appreciate your briefs, your oral argument, and we will endeavor to render an opinion at the earliest possible time. I realize I don't think there's any need to move, or are y'all going to make y'all doing the same one? Okay. All right. So what we will do then is move into the second case. Ms. Angie, if you will call that case, please.
Janet Doe versus City of Memphis, Tennessee.
Oh, take your time.
Just for the record, Your Honor, again, my name is John Lakey from the Shelby County Bar with the law firm of Birch, Porter & Johnson here for the City of Memphis. In this matter, I would request 4 minutes for rebuttal.
4 minutes. All right, sir.
Will you pull your mic up, Mr. Lake?
Absolutely. Thank you, Judge Golden. I'm sorry about that. So the instant appeal that we're going to discuss now, Your Honor, really presents 2 different issues. First, The city submits that the claim of the lone remaining named plaintiff, Janet Doe, against the city is time barred under TCA 29-20-305B. And separately, that was a motion for summary judgment that we had before the trial court that was denied. And then, and I'll discuss this, but the court also, in denying our motion for summary judgment, made an affirmative finding that the special duty exception applied in this matter, not just to the plaintiff, but apparently to all potential class members. And so that's the second issue, and the other issue that we're asking this court to reverse the trial court on. Of course, these are both legal decisions that the court has de novo review on. And I know you've heard, and I promise I'm not going to go over the same facts, but I know you've heard some of them, but I do think it's important to put it in a little bit of context, and there's a couple additional things I want to add. So August 15, 2014, the initial complaints filed by Ms. Ebos, Ms. Graves, and Ms. Johnson. It's amended about a month later, so I'm going to refer to that, if it's okay with the court, as the initial complaint, and the three plaintiffs as the initial plaintiffs. Brought under the Governmental Tort Liability Act, asserting claims for negligence and reckless conduct. The reckless conduct claims have been dismissed by all, including the current plaintiff, Ms. Doe. And indeed, all of the claims brought by the three initial plaintiffs have been dismissed. The initial plaintiffs all allege they'd suffered severe emotional distress as a result of an announcement by the city of Memphis in August and October 2013, the announcement that I've already described, which is why I wanted to make sure that date was before the court. The initial complaint, as I think Judge Bennett noted earlier in the first matter, the initial complaint sought $1.4 million in damages with maximum recovery of $700,000 against the city. As it turned out, at the time of that 2013 announcement, each of the initial plaintiffs knew that their SAK had been tested. They knew that the perpetrator of their sexual assaults had been apprehended, and indeed that the perpetrator of their sexual assaults had been convicted. The same perpetrator assaulted each of the three initial plaintiffs. Each of those initial plaintiffs' claims had been dismissed. Ms. Ebos' claim was time barred, and Ms. Johnson and Ms. Graves dismissed their cases after the city's summary judgment motions established that their SAKs were submitted to TBI, in one case within a day of it being collected, and the other one within a few days of it being collected. And as I noted earlier, under the plaintiff's proposed class definition, at least as it was set forth in the motion, it would implicitly suggest that these three women would still be class members. So the only remaining plaintiff was amended as a named plaintiff on October 16, 2015 in a second amended complaint. Ms. Doe was sexually assaulted in 1997, and as we discussed earlier, I won't go over again, that was pre-CODIS. Ms. Doe became aware that Memphis had not tested SAKs in August 2014, over a year before she was first identified to the city of Memphis as a possible plaintiff. And in that second amended complaint, plaintiffs sought $10 million in damages and alleged that each plaintiff suffered a separate injury and that there was no cap. The trial court
there was no what?
There was no cap available under the GTLA, and they've got a pending motion before the court, the trial court in that regard. The trial court denied the city's motion for summary judgment that Janet Doe's claim was time barred under 29-20-305B, finding that Janet Doe's claim was either equitably towed under American Pipe and Construction Company versus Utah, a 1974 United States Supreme Court case, or alternatively because relation back under Rule 15.03 was satisfied for purposes of determining whether her claim related back to the filing of the initial complaint in 2014. That being said, there is no real issue that unless the trial court is correct, under the undisputed facts, Janet Doe's claims would be time barred unless equitable tolling applies or relation back applies. And we submit that it is time barred. So let's turn first to 29-20-305B, which provides that any action brought under the GTLA must be commenced within 12 months after the cause of action arises. Because it's part of the GTLA's limited waiver of the government sovereign immunity, this provision is to be strictly construed and confined to its express terms. That's statutory. So equitable tolling, and we suggest that the court mistakenly applied equitable tolling in this case for 3 reasons. First, there are no Tennessee Supreme Court cases or courts that I'm aware of that have adopted federal class action tolling. There's simply no law in Tennessee. In fact, the only law that exists is to the contrary. Even if Tennessee courts had adopted American pipe tolling with regard to class actions, it would not and could not apply to 29-20-305 because it has to be strictly construed and confined to its express terms. And then finally, even under the federal doctrine under American pipe, it has not been extended to statute of reposes, and we believe that 29-20-305B serves as both a statute of limitations and repose. I want to turn to 29-20-305B and why it has to be strictly construed and confined to its terms. Tennessee cases are clear that it has to be construed and confined to its terms. It's actually set out in 29-20-201C that when immunity is removed under this chapter, under this section, claims must be brought in strict compliance with the chapter. And on its face, it does not permit exceptions to expand that statute of limitations. So suggesting that you can use equitable tolling to then expand it is contrary to Tennessee law, which we've cited in our briefs, and to the notion of what the GTLA was intended to do, which was identify the areas in which it would, where the Tennessee legislature would step in and remove immunity of governmental entities. So that leaves me about 3.5 minutes to talk about relation back. There is, the plaintiff cited, and we have never combated this issue, that there's certainly Tennessee case law that suggests that TRCP 15.03 can apply to the statute of limitations or repose that's set forth in the GTLA. We don't dispute that. But under Osborne, the 3 primary considerations to see if relation back to the original pleading to avoid a statute of limitation, what are those? Whether the defendant received adequate notice of the claim, and whether relation back would prejudice the defendant, and 3, whether the identity of interest between the originally plaintiff and the new party plaintiff exists. Have to meet all 3. So with regard to the first one, whether defendant received adequate notice of the claim. When it's a new party, not only must the defendant have notice of the operational facts, but it must have had fair notice that a legal claim existed and was being asserted by the party belatedly brought in. So remember those 3 initial plaintiffs. Those 3 initial plaintiffs were all sexual assault victims that had had their kits tested after the advent of CODIS, and so the entire defense and the strategy to that point was focusing on post-CODIS sexual assaults. This is a really different set of facts when you start going back to pre-2002. Not only that, what the plaintiff says is you had...
Do we focus on what your defense is or what the plaintiff's allegations are?
Well, I think you have to get, one of the things I think the court has to do is look at whether the operational facts give rise to distinct claims or defenses among the claimants. And I think you do have to look at the defenses that would be available to us based on relation back, Your Honor. I think that's what one of the things that Osborne says. We've talked a bit about why the operational facts here are so different. Ebos was sexually assaulted in 2003, Graves the same year, post-CODIS. Johnson was sexually assaulted in 2010. Both Graves and Johnson's alleged mishandling and ultimate SAK testing was contrary to the undisputed evidence, and we were able to realize that very quickly. All three of them alleged that they and similarly situated persons suffered severe emotional distress upon hearing the city's public announcement regarding untested SAKs in August 2013. That's not really Janet Doe's allegation. Janet Doe's allegation is that there's been a mishandling of her sexual assault kit, and that you've heard what Mr. Smith said, it was 18 years before it got tested. That's a different set of operational facts. And then really also importantly is that the nature of the claim changes when the plaintiff demands $1.4 million capped at $700,000 per governmental entity in the first complaint, and then the one they wanted related back for Janet Doe claims $10 million with each of the claims being uncapped. Excuse me, Your Honor, I'm out of time.
Thank you.
Gary Smith at the Memphis Bar for the plaintiffs. I want to address both the issues that he did talk about, which was the tolling issue and the relation back issue. He did not address, as they did in their brief, the public duty doctrine defense. And I hope to have time to speak to that too, because it's important. First of all, Mr. Lakey argues that Tennessee has not adopted equitable tolling. There is no case that says they have. There is no case that says they haven't. The U.S. Supreme Court says it applies under Federal Rule 23, and the Tennessee Supreme Court in the Tig versus Pirelli tire case commented extensively and favorably about about the American Pipe doctrine of equitable tolling, but said that they need not reach that issue because of the Davidson County local rule that was controlling on the timing of class certification. But it is pretty clear in Tig what, if the issue was before them, the court would do. It's interesting that if you do not...
So that's dicta, right?
I don't think it would be considered dicta. Usually
But it
is not
wasn't
as
necessary.
exhaustively explored as they do in Tig, because they go, at great length talking about the virtue of it, but saying, but in the end, we don't have to reach that because of the Davidson County local rule being controlling. But one of the obvious things about equitable tolling pursuant to American Pipe is that a defendant in a Rule 23 action would simply have to wait, say 1 year plus a day, settle with the representative plaintiff, and it destroys the other potential thousands of cases. Or the same thing would apply if the lead plaintiff happened to die. Equitable tolling should be recognized. Now, they try to say, as he just suggested a few moments ago, that Tennessee authority that does address equitable tolling has denied it. But that was on cross-jurisdictional issues.
There's nothing, what I think I hear you saying is that there's nothing that would prevent this court from adopting equitable tolling if we thought that was appropriate, because the Supreme Court has not refused to adopt it.
That is absolutely correct. They have only spoken to it favorably, but have not had the exact issue before them. You're correct. So the cases that they cite where the Supreme Court did not go with equitable tolling was only on cross-jurisdictional issues, and they were clear to distinguish the reasons for that being different than it would be for intra-jurisdictional equitable tolling. On the relation back issue, what Mr. Lakey fails to point out is that In the Doyle case, the Tennessee Supreme Court says that the relation back under Rule 15 applies to the government. And as he acknowledged, it applies both as to a statute of limitations and a statute of repose. Ms. Doe was substituted in as a plaintiff with this original case still pending. This is classic Rule 15, relation back, end of story, full stop. It is. It cannot be argued otherwise. Now, he seems to say, and did say, that when Ms. Doe comes into the case, that the city somehow is prejudiced because they are not on notice of this claim. The same claim that he contended in the former argument that was announced by the city, which put these claimants on notice. You cannot be unaware of that which you yourself are proclaiming to the public you've been caught at. They clearly had notice. And the only people, the only entity at that point in time, and frankly to this day, that knows the identity of all the potential claimants is who? The city of Memphis. They are the ones that have that information that has still not been produced in our discovery. They cannot, with a straight face, suggest that they were surprised by the addition of Ms. Doe or that they were surprised by the allegations in the class that they were being sued for failure to test rape kits and or to test them timely. They knew all the information because they had all of the information, and they still do. Now, I do want to address the public duty doctrine, which he did not address in oral argument, but they spent a great deal of time on in their brief. An issue that the trial judge disagreed with them on, and I really have two things to say about the public duty doctrine. I need not remind this court that this is not the first time you've recently heard this issue come up post-Lawson. There are at least two other pending cases in the pipeline, if not three, on this issue. Chief Justice Kirby and Lawson, in her concurring opinion, invited the issue to come up to them again for consideration of whether or not the public duty doctrine is still viable, particularly in view of Lawson. So what the Supreme Court said in Lawson was that since the Governmental Tort Liability Act was in derogation of the common law, it must be strictly construed. And because it must be strictly construed, the only exception relative to the standard of conduct permitted under the GTLA was for common negligence, not recklessness. Ergo, recklessness could not be used as a cause of action under strict construction. But it's important to remember this. The public duty doctrine preceded the adoption of the Governmental Tort Liability Act. In Chase and Ezell, the court has addressed the public duty doctrine and its parameters, and it's been suggested and said in those cases that it survived the public duty doctrine, but that was before Lawson. Therefore, it is very important here to remember and recognize that when the Governmental Tort Liability Act was passed and allowed suits for negligence, which had to be strictly construed for the type of cases that could be utilized as causes of action, similarly, the statute created exceptions. So strict construction on causes of action allowed has to be measured identically to the type of exceptions to that. Strict construction on one, strict construction on the other. And strict construction of the exceptions permitted under the GTLA would not include those under the public duty doctrine. So it is time for the abrogation of that doctrine, and Lawson creates the vehicle to do it. But even if the court were to disagree with that, or actually agree with it, but say it's not this court's responsibility or prerogative to do that, it's that of the Supreme Court, then we have to address, well, if the public duty doctrine does still apply, was the trial court correct or incorrect in holding that the special duty exception was applicable? We contend that there are two of the exceptions to the public duty doctrine that do apply in this case, and the first one is the special duty exception, where if the city undertakes an affirmative act to protect the plaintiff, there is a special relationship, a special duty, and that applies here because they required the victim to submit to a sexual assault kit, as I've indicated previously.
They required? I thought it was up to the victim to decide whether they wanted to participate in that.
The city in pleadings in this case has acknowledged that they require it. Now, in fairness, could a victim just absolutely refuse to do it? Sure. But as far as the city is concerned, when they tell you, you're going to do this rape kit, could they refuse it? Of course. But they don't. And they didn't. We know that. That is an affirmative act. But the affirmative act has to go further than that, and that is that it has to be an affirmative act for the protection of the plaintiff. Now, we say, number one, that the investigation and the utilization of that kit, which Lieutenant Cody Wilkerson of that department says the most important part of investigating a rape is to identify the perpetrator and protect him from the perpetrator. But there's also a medical reason, because the information to be derived from that kit will also have a medical benefit to the victim to let them know whether or not they have been subjected to sexually transmitted diseases or not. So there's more than one reason.
In all fairness, that's not really the primary purpose of the city, though, is it?
It is not the primary purpose, but it is one of the reasons, and it is one of the benefits, which is...
It's a benefit, exactly. I totally agree. And it's a wonderful thing that they go ahead and do those tests. But as far as the city's concerned, they care about the investigation aspect of it and getting the DNA of the perpetrator.
That's what they should be motivated by. We know that it wasn't because they didn't test. But the key to your question is what is the language under the PDD, Public Duty Doctrine? And that affirmative act is to protect the plaintiff. That happens to be one of the ways in which the victim is protected. We also say that the third exception, the reckless, applies notwithstanding Lawson. Lawson only says that you can no longer use reckless conduct as a cause of action. So if the public duty doctrine survives Lawson, though we say it should not, but even if it does, then these exceptions still exist. And if the court has the right, beyond the GTLA, to create the public duty doctrine, it also has the right to create the exceptions and the standards of conduct which will allow that public duty doctrine to exist. And in this case, the court has said, under the public duty doctrine, if your conduct is intentional or with malice or reckless, you cannot use public duty doctrine as a defense. Lawson does not disturb that fact. If the public duty doctrine survives, then the court can create the standard of conduct that will allow that defense to be used. And reckless conduct can operate to negate the affirmative defense of the public duty doctrine on which the city bears the burden of proof. So even post-Lawson, if that doctrine still exists, number 3 still applies. Any other questions? Thank you.
Thank you. think you have 4 minutes, Mr. Lakey.
Thank you, Your Honor, and two primary points. So, first of all, no, the court is right. The city does not require that women submit to a sexual assault kit. It is not in the record that we do. And in fact, I'll just point the court to what the trial court said in her order denying our motion for summary judgment, where one of the things that she says on page 9 of that order at subparagraph G is the city invited them to submit to sexual assault kits. They don't demand. You don't demand that someone submit to a medical examination. There's nothing in the record that says that. With regard to the issue of the special duty exception, and I had the pleasure of arguing that recently in front of this court, just think about what Mr. Smith says. Unless this court is going to adopt a new special duty exception, that is that every person who submits to a sexual assault kit is now has a special relationship, and the city owes them an affirmative obligation, owes them specifically a duty. Unless the court's going to do that, then the trial court, in deciding whether the special duty exception applies for any of these 12,000 people, is going to have to do an individualized inquiry. Consider what you'd have to look at and what the court has had to look at when looking at whether the special duty exception applies in the scads of cases that have decided it. They've all been fact intensive. The facts will matter. Why was this investigation closed? What did the perpetrator admit that they'd had sex with you? So was then it reckless, or was it intentional conduct to then not test it? That's going to drive individualized inquiries. Those are the type of individualized defenses that keeps this court from finding that commonality or typicality can exist in a case like this.
So if a special sexual assault kit creates a special relationship, I mean, where do you draw the? I know it's intimate. I know it's intensive and a horrible experience. But there's all kinds of other things that police do that are taking evidence, physical evidence off something. They scrape fingernails. They search for hair samples on a coat. They do all kinds of things. And where's the line? Where's the line drawn?
I don't think you can draw the line, and I think the line has already been drawn by the special duty exception, and it requires an affirmative step to protect and reliance, but it's an affirmative step to protect. And it's, look, I don't want to compare any crime to a sexual assault or minimize.
No, I mean, it's a terrible thing, and I don't mean to minimize it by suggesting these other things, but my concern is there are other things that could be said to create a special relationship if a SAC case can.
That's right, and you can think of a murder case where a family's home has to be, taken over by the police and looked through intimately. There is not a line to be drawn. And the last thing I'm going to say, that I see my time escaping, is I'll commend this court to read TIG. I don't think the TIG court, in essence, trumpeted equitable tolling in it. And I don't think this court should apply it. Thank you, Your Honors.
Thank you. Thank you, counsel, for your argument. We will take this matter under advisement. We'll review the briefs, the record, and endeavor to get an opinion to you at the earliest possible time. We will stand in recess to the call of the docket this afternoon. Ms. Angie.
All rise.
Thank you.